Good afternoon, everybody. This is Carol Razzo from ElderWorks, and thank you very much for joining us today. We're delighted to have everyone. Please, I'm sorry, please mute yourself and also your video during the presentation. And then as Melissa is speaking today and presenting, then we will have questions. And Melissa, would you prefer to have questions during the presentation or hold them until after?
During.
Okay, great. So you can jump in anytime. Put them in the chat box, please, and I'll be watching there. We are also streaming live on Facebook. I've put my contact information in the chat box, so if you have questions or concerns afterwards, you can always contact me. Today, it's our pleasure also to have Senior Helpers, Gina Goggio from Senior Helpers, as our sponsor. Gina, would you like to tell us a little bit about Senior Helpers and all the wonderful things that you offer as a very trusted partner with ElderWorks?
Thank you, Carol. My name is Gina Goggio, and I'll put my information in the chat box also. I'm from Senior Helpers. We offer in-home non-medical care. We can do it on a 24-hour live-in or hourly basis. We are unique in that we do offer a short shift of a 1 hour or a 2-hour shift that we can do for you in case your loved one needs that kind of help. We are also a member of the Veterans Care Network, which means we are authorized to provide care to senior veterans.
Thank you. And Gina, we really appreciate you joining us today and being our sponsor. And we also appreciate all the wonderful services that you bring to our clients. And so we thank you, and thank you to Senior Helpers. I am with ElderWorks, as you know. I'm Carol Razzo. I'm the Senior Strategy Director. And basically, I think most of you know that ElderWorks helps all seniors, families, professionals. We are able to help with housing. We are able to help with in-home care, of course, which we rely on with Gina's group and others that we work with. And in addition to that, we just published our new directory, our 2021-22 ElderWorks Senior Directory. That is available at our location in Palatine, or we have other drop-off points. So if you need one of those directories and books, it is really the most comprehensive resource for seniors and professionals in the Illinois area. You can always call our office direct regarding other pickup locations, and that is 847-462-0885. And Emily, who is our office manager, will help you with additional drop-off locations. We appreciate everyone coming in today. We have a wonderful relationship and a very trusted partnership with Dutton, Mesoloras. And today, Melissa Kallio, the one of their elder law attorneys, is going to join us and present long-term care. Medicare does not pay for it all. And I think you'll find it extremely interesting and informative. And Melissa works with many of our clients, as do the attorneys at Dutton, and Mesoloras. I also want to mention that they have an excellent and wonderful social worker and care manager, Erin Vogt, and Erin really is primary in helping many of our clients as well, and directing you for all your needs to the proper attorney at Dutton, Mesoloras. So Melissa, thanks so much for joining us today. If you have, this is an interactive town hall, so if you have questions, put them in the chat box. I'll be watching the chat box, and as appropriate, we'll request or give the questions, and Melissa, you can see them as well if that's convenient for you, and we'll go from there. So Melissa, go right ahead, and thank you so much for joining us today.
Thanks for having me, Carol. I really appreciate any opportunity to talk about this particular topic, which is long-term care. Medicare doesn't pay for it all. As was mentioned, I am an elder law attorney at Dutton, and Mesoloras. So this is something that I deal with every single day. So it's something that I'm just very familiar with. And quite frankly, I could probably talk about this topic on my own for at least an hour, but I welcome you to submit your questions. It gives me a little bit of a break, and I really, truly do want to make this something that is informative for everyone and make it more of an interactive type of presentation. So to just get us in the right frame of mind, when we're talking about long-term care, we're talking about if you needed assistance in the future with activities of daily living, or maybe right now, how would you access it? So activities of daily living, including driving, meal preparation, bathing, toileting, dressing, and transferring. I think these are things that it's a reality for a lot of my clients, and it's something that more and more people I've noticed, especially during the pandemic, are really thinking about. And how would we access these services, and then and really how would we pay for it, because that really ends up being a huge consideration for people. So paying for long-term care, we're looking at 4 different sources of payment. So we've got Medicare, we've got private pay, we've got long-term care insurance, and then we have Medicaid, which is generally which is really the bulk of this presentation, but we will just kind of touch on Medicare. And so I think it's really interesting to me, because I do get a lot of people who come to me for the first time, and they just think that Medicare is going to be the solution, that Medicare is going to cover everything. And, that is just simply not the case. And I think there's a lot of misinformation out there. And so, that's kind of where the topic for this presentation came, is that just over and over again, myself and the other attorneys at my office were seeing people come in thinking Medicare is the solution and Medicare is the fix, but it's not. And I think that, when we're talking about the cost, we're talking about covering either in-home care or nursing home care for individuals who need assistance with daily living. It's largely an uninsured healthcare cost for most individuals, and planning for it is necessary for effective retirement planning. So when we're talking about Medicare coverage in a skilled nursing home, I think what's really key is it's just up to 100 days. And it's following an inpatient hospitalization of at least 3 midnights. So Medicare will cover the full cost for the first 20 days. And I think that's where a lot of people kind of get lulled into this kind of false sense of security of, okay, maybe perhaps in the past, I was hospitalized. I just needed some rehab. I didn't have to pay anything. So, if you come back to me and then you're looking at a longer term stay, there's kind of this sense that, oh, well, Medicare covered it the last time for me, so it's going to cover it again. But that's not the case. It will cover the full cost for the first 20 days. And then there's a co-insurance for days 21 through 100, which we listed the amount for 2021. But most of your Medicare supplement policies are going to cover that co-insurance. So again, I mean, there's still a nice benefit of getting that potential full coverage, nothing owed for up to 100 days. Medicare will also provide home care to individuals needing intermittent skilled care, usually post-hospitalization, although there are some long-term part-time skilled care services covered. But what's really key is that skilled care does not cover custodial care, which is the type of long-term care that most individuals who have your dementia diagnosis actually require. So, when we're looking at Medicare cover or Medicare's coverage of custodial care, it's really lacking. And so that's again where we see another shortfall with what Medicare can do for people. After we look to Medicare, we can then look to long-term care insurance. I'm seeing a lot more people who have this, a lot more people who decided, however many years ago, that this was something that was going to be beneficial, that I should get a long-term care insurance policy. And it can be a really, really nice benefit for a lot of people. It's the only health insurance that's going to pay for custodial long-term care, either at home or in a formal care center. So your typical long-term care insurance policy has some just kind of basics to it. There's generally a policy limit, as in, we're only going to pay out this much over the entire course of you needing this policy. There's also typically a stated daily rate. So they may say, we will pay $250 a day. or we're going to pay $350 a day. There's also typically an elimination period. So some time has to go before this policy is actually going to kick into effect. So I've seen this work really nicely for some people, especially for people who have policies that will cover long-term care services at home. It really allows them to extend the time that they're able to stay at home because they have this policy. I've also seen it work really nice in a the institutionalized setting where it can cover all or maybe part of the daily cost at a facility, which really opens up a lot of options for people, because then that way they don't have to just completely exhaust their savings. If they have any, they can rely on this benefit and just supplement it with their savings, which, it can open up options in terms of the facilities that are available, and where these people can live longer than perhaps maybe they would be able to if they had to look to some of the other options. So when I talk about other options, I guess I'm really just talking about one option, and that is Medicaid. And Medicaid consultations, applications, appeals is just something that really comprises a bulk of my practice. And I think in part because the rules are pretty complex and can be pretty confusing. And then also just due to some of the misinformation that's out there about the program. But we do, increasingly people have to look to Medicaid to cover their long-term care costs because, as I mentioned, Medicare is not going to cover it indefinitely. And long-term care insurance is going to have its limits. And then, of course, our private savings for most people has its limit as well, right? Most people, especially as you continue to stay in a nursing facility and use your savings, it's likely going to hit a limit. And so that's where we look to Medicaid, which is our payer of last resort. It is a federal and a state program. All of the law derives from federal law, and the federal government still monitors the states implementing the program. But then we've got our state law, and this is where we get our regulations and our policy. And the states are the ones who are actually going to make determinations on whether someone is eligible, and then move forward with the actual payment to the facilities for people who are eligible. So our state Medicaid agency is the Department of Healthcare and Family Services, who actually makes the agency that actually makes the determination about whether or not someone's eligible is the Department of Human Services. So I may refer to that department pretty frequently as DHS. As it's kind of commonly known. So that's kind of our framework for how we go about Medicaid in this state. Illinois Medicaid will cover the costs in a traditional nursing home, which is what most people are familiar with. But they do also cover some programs, and they cover them under what we call a waiver, which means that the state of Illinois has received special approval from the federal government to cover services in a non-traditional setting. And it allows individuals to live in settings that are not defined as institutions, so such as their home or as a community setting. So some of the programs we have in Illinois that are waivered, we have the community care program for people who are over 60. We have in-home services for people who are under 60. And then we also have supportive living, which is not necessarily an institution setting, but it is more of a community setting, kind of comparable to, I think, what a lot of people think of as an assisted living setting. So those are some nice options. And I think, there's been a real push, and I think especially as elder law attorneys, we've certainly pushed for there to be more and more waiver options, because we think that a lot of clients I see, cost has really ended up being the big decision that has kind of forced them to move into an institutionalized setting. And so opening up, some of these waivered programs really gives people some opportunities to kind of age in place when otherwise it would be cost prohibitive. So I think that that's something that we're certainly kind of tracking what's going on with the legislation in Washington to see if those types of programs are going to continue to be protected as well as perhaps expanded. So that's why we're looking at Illinois Medicaid actually covering the types of services. I do also believe there's a lot of misinformation out there about, people know, okay, Medicaid will cover me in a nursing home. Well, then it follows that, shouldn't they just, if they're willing to pay $5,000 for me to stay in a nursing home, shouldn't they just give me $5,000 to cover my services at home? Fortunately, that's not the way that it works. I think there's if you think about it, the state really would lack the ability to kind of supervise the services that you're getting and making sure that their dollars are being used appropriately. So I hope, Gwen, that I answered your question with waivered. What waivered means is that it means that the federal law set out what Medicaid can pay for, and that is traditionally services of a skilled nursing home. If a state wanted Medicaid to pay for something else, they have to apply for what's called a waiver with the federal government. And so the waiver says, okay, in a way we're waiving our requirement that you only cover nursing home care. We're going to allow you to cover these other programs. So we're giving you a waiver, and then we use the term waivered to kind of indicate that. So Carol, yes, please jump in, add something on supportive living.
Yes, so supportive living, what I wanted to mention, thank you, Melissa. Excellent explanations here. What I wanted to mention on supportive living is I always say to our clients when I'm talking to them about this as an option, often people have a limited amount of availability to pay for care. And they have some money, but they are going to have to transition to Medicaid. So my explanation is usually think of supportive living as a community or a building that has a special license, and they accept private pay people as well as those on Medicaid. And generally it's independent and assisted living, as you stated. The difficulty sometimes comes if they need memory care. We have some locations, communities, buildings that have memory care, but there are not a lot of them. So it's always important to do this planning in advance. But supportive living is an excellent option for anybody that has limited funds, which most of us do at this point because care is so expensive these days. So thanks, Melissa.
Yeah, and Carol too, maybe if you could just, I always, when I'm explaining supportive living, I always kind of draw an analogy to assisted living, but it is a bit different. So I don't know if you can just chime in on what is like the level of services that's provided in a supportive living facility.
Very, very good point. Any community or building, and I usually say to people, think of it as a building that has care that has been given a specialized license. And if the person coming in is eligible for this, which means they'll be eventually going to Medicaid or they are on Medicaid, essentially, if they need assisted living, it's limited as far as what the options are. So if you need shower standby assistance, you need medication management, you need reminders to go to the dining room, all of that is generally available. But when you're in a supportive living environment, and we get back to what you said, activities of daily living, the ADLs, when that becomes a greater need where you're now having, perhaps you're a two-person assist, you may be in a wheelchair and you can't get in and out of bed on your own, or you need more assistance on an ongoing daily basis. Supportive living locations in assisted living, so you're in assisted living, often do not have the staffing and the extensive amount of services that other assisted living on a private pay basis would. So when you get to that, sometimes you end up then in skilled care or nursing home care. So it's limited assisted. It's not ongoing high level assisted living.
And I think too, another thing is I've had this a number of times with clients where they get approved for Medicaid and they're in a supportive living facility. But then as Carol mentioned, as their condition progresses and they need a higher level of care and they have to transfer to a nursing home, the nice thing about getting that Medicaid approval for the supportive living facility is that actually will then transition to the nursing home. So it's not as if you apply once for Medicaid when you're in a supportive living and then you have to apply again when you're in a nursing home. Nope, the eligibility determination is the same. And so it just transitions nicely. So that way people who don't need that level of nursing home, they don't just have to go to a nursing home to try and get Medicaid. It can transition from one level to the next.
The other thing that I think is worth mentioning is when you already have that Medicaid approval, it makes it really easier to find a location if you have to go on to another level. And I think also it's worth stating that it's always best to work with the elder law attorneys, such as Melissa and her group, in order to get Medicaid assistance. I've had during COVID families that realize they're going to have to place someone and they need Medicaid, and they have gotten the application and decided they were going to apply themselves. And I've said, that doesn't normally work. So you might want to mention that.
Absolutely, yeah. And I will put out some pointers as I go through the Medicaid rules, because there's a lot of spots where people can get tripped up doing their own applications. So I do just want to address the question, does community care include adult daycare programs? If not, what is community care? Yes, the community care program, CCP, as I'll refer to it, does include adult day services. So what I will point out is that there's providers. So typically it's kind of local social services agencies who kind of administer that program. So while you do, and it does have a little bit different of eligibility requirements than what is going to be applied for supportive living or nursing home. You can have a bit more in assets to be eligible for that program. But to just simply answer the question, yes, it does include adult daycare programs, and it can include quite a bit more services as well than just the adult daycare. Okay, so moving on. So we're going to talk now about Medicaid eligibility and what we have to do for someone to actually get payment from Medicaid for the services that they need. And so three categories here generally of what we have to establish for someone to become Medicaid eligible. So residency and citizenship, categorical eligibility, and then need. Always remember that Medicaid is a needs-based program, whereas Medicare is not. Medicare is an entitlement program. So just keep in mind, Medicaid always has to be associated with need. So citizenship. So only residents of Illinois are eligible for Illinois Medicaid. That is pretty logical. You have to be voluntarily living in Illinois, but one of the things that's kind of interesting and is not the same in all states is that there's no durational requirement. So I have actually had situations where, I'll just give one example. A client, she was residing in Florida. Her and her husband had retired down there. She was in a nursing home. The family decided it would make more sense for her to be in a nursing home close to her kids and for her dad to also move up here as well. So mom took a very expensive ambulance or Medicare ride from Florida to Illinois. And the day after she got here, we applied for Medicaid. So there's no durational requirement. She didn't have to live here for 6 months in order to get Illinois Medicaid. That is not the same in all states. And what's also interesting is that this lady was on Medicaid in Florida, but we can't transfer Medicaid approval from one state to another. It is state specific. So we had to reapply even though she had already established her eligibility in Florida. But just kind of an interesting point. Some states will have a durational requirement, but not Illinois. And then of course the intention to remain in Illinois. So, if someone's maintaining a home or something else, that Illinois residency may not be established. So citizenship, again, only U.S. citizens or lawful aliens are eligible for Medicaid. I don't really think there's necessarily anything that's super surprising about that. And so I've listed on this slide just the requirements for permanent residency, and then what they ask for to actually document your U.S. citizenship. And you do actually, as part of your application, have to provide certain proofs, certain identifying information that would support that. So Medicaid eligibility income limitations. So when we're going to be talking about Medicaid eligibility, we'll talk about it in the context of income, assets, and then reviewing what you did with your income and assets before you actually applied for Medicaid. So in order to qualify for Medicaid coverage, the resident's countable monthly income has to be less than the private pay rate at the facility. So just an example of that, if the private pay rate at the facility is $10,000 a month, your income has to be less than $10,000, your countable income. It's kind of logical, because if you're getting $15,000 in income each month, then you're able to pay your $10,000 bill from the facility, so you don't need Medicaid. I will just put the caveat that different income rules are going to apply for the community care program, so this would really be specific to someone who's in a supportive living facility or in a nursing home. So income in the community spouse's name is not considered available to the nursing home spouse. So I think this is really important, and another part of a lot of misinformation that I see out there. So if an individual is going into a nursing home and they have a spouse who's still living at home, then we refer to them as the community spouse. And I think that spouse likely has income in their own name. Well, that does not count towards the community spouse's or towards the spouse who's in the nursing home's income. So I have had many people come to me and tell me that the nursing home has told them, or the supportive living has told them, that spouse who's living at home, that income counts and that has to be considered. That is not the case. That is actually considered separate. It's different when it comes to your assets, but for income, that's considered separate. And we refer to this as the name on the instrument rule. So whoever name is on that check, whoever name is associated with that Social Security or that pension, it's their income. And then we have to look at the rules as to how that income is considered when we're applying for Medicaid. So we always start with that the Medicaid recipient's income has to be forwarded to the facility on a monthly basis, less certain deductions. So if my husband is in a nursing home, then we start with his income. Let's say he's getting Social Security, has to go to the facility every single month. But before we do that, let's try and take advantage of some of the deductions that we can take from that. So the first is a personal needs allowance. So $30 for people who are in a skilled care setting, and $90 for veterans and people who are in supportive living. So automatically we can take off his personal needs allowance. So the community spouse income allowance. This is a very specific rule, and that basically says that if me, as my husband's community spouse, if I do not have my own income of $2,739, let's say I just get $1,000 a month, then I can take from his income to get myself up to $2,739, which would mean if I only have $1,000, I could take $1,739 of his income before he has to turn anything over to the nursing home. Family maintenance needs allowance, not something I see a lot of. I think I've only ever had a couple cases where we've been able to take advantage of this. But essentially, if there are dependents, you are able to take some more from the institutionalized spouse's income. And again, it's very similar to the maintenance for the dependent child under 21 not residing with the community spouse. Amounts to cover Medicare and other health insurance premiums. So let's say that my husband, he has a prescription drug plan and he is paying, $40 a month for that. We can also deduct that from his income before we turn it over to the facility. So then this last category is kind of just a catch-all, basically. So amounts to cover medically necessary items that are ordered by a physician but not paid for by Medicaid. And as long as that's remaining my husband's liability, let's say he had a prescription, there's a copay left over of $20, no one's covering it. What we can do is we can deduct that from his income that he turns over to the facility. Check this question. So we will talk about the 5-year look back period. The question is, so the spouse's income is not included in a 5-year look back period. The answer is that yes, they will review what the spouse's income, what was done with it over the 5 years. But the key of what I was just talking about is that they do not look to the spouse's income when someone is in a nursing home and on Medicaid. They are not able to demand that the spouse turn any income over to the nursing home. So it's that name on the check rule. They can keep their own income. Now, if they have income that's more than $2,739, they can be subject to a responsible relative payment from the state. I believe I've got some more on that in some different slides, but the 5-year look back is something different from what I was just mentioning. And I will get to the 5-year look back and what they're able to look at over those 5 years. So Medicaid eligibility asset limitations. So when some of these, they're just very simple. When we have a couple who's both in a long-term care facility, $3,000 in countable assets, not a whole lot. A single Medicaid applicant, $2,000 in countable assets. Again, not a whole lot of money. But the key word there is countable assets. So there are certain assets that are not countable towards the asset limit. So I've listed just some of them, and I'll go into more specifics in future slides, but the homestead property under certain circumstances, personal effects, motor vehicle, life insurance, burial funds, and burial space and merchandise. So homestead, it is the property in which a person has an ownership interest and serves as their place of residence. So in order for me to make that not countable, I would have to demonstrate one of these 3 things: the intent to return or occupancy by the spouse. So in my situation with my husband in the nursing home, if I'm residing in our home, it's considered an exempt asset. It does not count towards the $2,000 that he is permitted to keep. Similarly, if he submits a statement of intent to return to that home, perhaps he is just in a nursing home for a short time period, and he is intending to return to it, then it will also be considered exempt, but it is possible for Medicaid to file a lien. A child, if there's a child who's under the age of 21 residing in the home, or if there is a disabled child in the home. And lastly, I think I misspoke, we've got 4. So we've got a caregiver child who resided with and provided care to the applicant 2 years prior to the long-term care admission. That is a huge, huge one. I see a lot of what we call caretaker child Medicaid applications, where we are actually able to exempt the home and then take it one step further and transfer title of the home to that caretaker child because they meet these requirements. So unless we have one of these above occupancies, the equity is going to be limited to $750,000, which really, honestly, I can confidently say this has never been an issue for me, because most of my clients, when we're talking about Medicaid applications, do not have a home with equity of $750,000 or more. So non-homestead real estate, I think this is really best explained with an example. And I've had it on a few occasions. I've had people who perhaps own a vacation property with some other people. I've got, some of my Michigan vacation homes, and, they don't want to sell it to go on Medicaid, but it's going to count, and they know that. And so what we've been able to do is either argue, you know, they've just got a small fractional interest and this is going to be a loss, so you shouldn't count it. Some people have actually listed it for sale, and some people have been able to get from these other owners that they're refusing to make their interest available for sale, which allows us to also make it exempt. So typically, if I'm dealing with this non-homestead real estate, I am dealing with someone who's got some vacation property somewhere or a second home of some sorts. So the question in here about, there's a question about if I have a joint account with my mom, does that mean that the cash and investments are non-countable assets? That's a good question. There's actually an entire slide on joint accounts and assets. So I'm going to just hold your question until we get to that slide. So personal effects and household goods are exempt to the extent that they are exempt under federal law. And so what we're looking for here is that Medicaid doesn't want to see that someone tried to dupe them by converting a bunch of their cash assets by buying up a bunch of gems or jewelry. You know, they're typically going to be okay with things that are, you know, hold family significance, family heirlooms, but they don't want someone to just be, you know, thinking, oh, well, personal property is going to be exempt, so I'm going to just convert all this cash and, you know, buy a bunch of jewelry and things here that I can just resell later and get the cash back. So that's, they're kind of really trying to avoid people doing those things. So motor vehicles, one motor vehicle will be exempt. And when I'm talking about exempt, I'm talking about not countable towards the $2,000 limit for a single person or $3,000 for a couple. It will be exempt regardless of the value if it's necessary for employment. Not something I see a lot. Typically what I see a lot of is the third bullet point, which is modified for operation by or transportation of a handicapped person. So I did have an application where we had a van that had been modified, and ultimately the value of this van was $30,000 to $40,000, but it wasn't counted towards that $2,000 because it was modified for this handicapped person. And I think, you know, Medicaid recognizes that that's an important thing for people who, while they may be on Medicaid, they still need this type of transportation. If it's not exempt, then Medicaid also won't count it if it's less than $4,500 in fair market value. And if it's over that, then $4,500 is going to count, or anything above will count. So cash value of a life insurance policy owned by the applicant or spouse is typically counted. I think when I'm having kind of initial calls with people, we try to walk through what assets they have. A lot of times life insurance kind of gets forgot because I think, you know, most of the time people buy life insurance and they, you know, they really do forget about it. They pay their premium, but because they're intending for that to pay out at their death, they don't really think of it as their current asset. But Medicaid is going to count it unless it's got a face value of $1,500 or less, or it's a term policy with no cash value. What they're really looking for is that you're able to get money out of it. So if you were to contact the insurance company and say, you know, I want to surrender my policy, and then you're going to get a bunch of cash out of that, then Medicaid's going to count it unless you've got a face value of $1,500 or less. So, you know, just, I always, you know, kind of stress to people that let's really make sure we got all our life insurance policies covered here, because that's going to count unless it meets one of these exceptions. So burial funds. I will say that when people come to me and they're looking at applying for Medicaid, my first comment or my first question is, did you prepay the funeral? Because it is absolutely allowable. And I think everyone can kind of agree that they would just really hate for anyone else to be saddled with those costs after they pass away. So Medicaid's got a few different options for burial funds. So there's, you know, up to $1,500 in a revocable contract. Funds in an irrevocable contract, there's financial limits to that set up by a funeral home, and those limits actually change yearly. The one that I am most in favor of is a prepaid burial contract funded by a life insurance policy. As long as that life insurance policy is set up correctly, the amount that can be done on that is unlimited. And that's the option I see most people taking because they don't have any sort of financial constraints. I also have a lot of people say to me, almost laugh at me when I talk about setting up a life insurance policy because they think, well, my mom or dad is 95 years old. There's no way they can get a life insurance policy. Well, my comment is that this is a really special and specific type of life insurance policy for this purpose. And I've never had someone with an issue actually getting one of those policies. So burial spaces and merchandise, these are also generally considered exempt as long as it's for the use by the applicant, the spouse, or any immediate family member. So I always encourage people not only, to have their arrangements prepaid, but also if they want things that are typically defined by Medicaid as, a burial space, such as the gravesite, which is typically a separate cost, urns, caskets, vaults, all of those do not count. Medicaid exempts all of those. So it's something to, just make sure we're getting done while we still have the money left to do it because it is completely Medicaid allowable. So joint assets, I saw one more question come in. So the question came in about life insurance. Can you keep life insurance if you are not taking cash out? So I think, the answer is really that you can keep your life insurance policy. The key is just that if it doesn't meet one of the exceptions that I noted on, if it doesn't meet one of the exceptions that's listed here, so if you've got a face value of $1,500 or less, if it's more than $1,500, it's going to count towards that $2,000 or that $3,000 that someone can keep. So even if you're not trying to surrender it, even if you're not trying to take a loan, it's still going to count. If it's a policy that you just simply can't get cash from, right? Your term policy, term life insurance policies, you can still keep it. And I think the question just becomes, and nothing counts towards your $2,000 or your $3,000 that you can keep. But the question becomes, how's the premium going to get paid? Because you're only going to have limited assets and then you're turning all of your income over to the facility. And so how would you pay that premium? Unless someone else steps up to pay it, it's just going to lapse. So you can keep it. It's just a matter of what's going to count and can you make that work? Okay, let me now move back forward. So joint assets. So this is another, I think, really a lot of misinformation out there about Medicaid's treatment of joint assets. So let's just start with joint accounts and personal property. So just your typical bank account. The presumption is that 100% of it belongs to the applicant. So typically this isn't an issue because the typical scenario is I have a Medicaid applicant who has perhaps a child as a joint owner, but the child is on there just for convenience purposes, or perhaps it was a probate avoidance tool. And the child is not really claiming any ownership of that. They know that that's 100% mom or dad's and that it 100% belongs to them and it has to be used for their expenses. So by simply just putting a child on there, it's not going to do anything because the presumption is that 100% of it still belongs to the applicant. Now, it's a presumption. So let's think about the reverse scenario. And I've had this happen multiple times. I have had children, perhaps, that child never married, has no kids. And for whatever reason, they have their mom or dad on their bank account. And we run into a problem because here we've got daughter has dad on her bank account. And now the presumption is 100% of this account belongs to dad in his Medicaid application. So when I've had that happen, I've actually had to provide proof to Medicaid to overcome this presumption. And so what we had to do was we had to show that daughter was the only one who contributed to the account, that it, collected her income. And in one of the situations that I had, the daughter was quite wealthy. So we really, and she wasn't too happy about having to provide her information to Medicaid. And I can't blame her, but the problem is that Medicaid has this presumption on their side. So that money is going to count. The only way for it not to count is if the applicant is just not associated with the account at all. So let me see what questions came from that. Does it matter who? So a couple questions. Does it matter who? So I'm going to do there's a couple questions about joint assets and then one on that life insurance policy that I'll jump back to. So first question is, does it matter who the primary social security number is? No. Presumption is still going to be that 100% belongs to the applicant, but as long as they're a joint owner. But I did use the fact that in that daughter situation that her social security number was the primary, and I was able to use that as one of my factors to overcome the presumption. So I used that. I used bank records and data that showed she was the only one who contributed to the account. I used an affidavit from her as to why dad was put on the account in the first place. And all in all, we were able to pull together enough evidence that supported that, you know, look, this really was just a convenience thing. He doesn't actually, you know, he does own the account, but it was never his money to begin with. So, question, can one have dad on as a signer and not as an owner? Is this a difference? Yes, it is a difference, because if you have someone with just signature authority, they don't actually have an ownership interest. So that would not trigger the account belonging to dad if he then has to apply for Medicaid if he's just a signer. So they jumped back to just really quick to a question about the life insurance policy. And the question was, if ownership of the life insurance policy is given to someone else, can they take it? So that is something that can be done. So people usually do one of two things when they come to me and they have a life insurance policy and it's going to mess with their Medicaid eligibility. You know, they will, most of the time they'll surrender it, get that cash value, and simply spend it down. Other times, we've got another family member who decides to take ownership of the policy. And so we do ownership change forms. But what we haven't talked about is that we're changing an owner, and that is considered a transfer. And if that falls within the 5 years of this person's Medicaid application, then what Medicaid wants to see in order to not impose a penalty because of the transfer is they want to see that the previous owner, who's now the Medicaid applicant, got fair market value in return for making that ownership change. So what does that mean? It means the new owner has to provide the Medicaid applicant with the cash value of the policy at the time the ownership change was done. So we'll talk a bit more about the 5-year look back and transfers, but that is the basic answer to the question. It can be done, but they have to provide fair market value in return for getting that ownership. So joint real estate, different than joint accounts and personal property. So the applicant's proportionate share of the equity value of the property is considered available, unless we've got it exempt for some other reason. So, you know, the common arrangement is this joint tenancy where we've got 2 people. So there it's 50-50. Life estate, I really just don't see a lot of these, but if someone has a life estate in a piece of property, it may be subject to a lien, and it can also be subject to some of the transfer of asset rules. But again, it's just not something that's very common that I see a whole lot of. Annuities. So annuities are considered an asset, and you have to disclose them. You have to disclose the ownership and the purchase of them. And if it's revocable, if it's available to that person, it's considered available. And any payments that are received are also considered available income. Medicaid has got some really, really specific rules about annuities. And so the rule is that if you fail to name the state as a remainder beneficiary after a spouse or disabled child on that annuity, we are going to run into some eligibility problems. So one of the things that I stress is I've seen a lot of nursing homes do applications for people with annuities, and there's not a whole lot of consideration going into actually evaluating the annuities and determining, what's the impact on this person's eligibility because of this annuity. When did they purchase it? What part of it, if anything, is considered available to them? What do we do with the income? And the rules are complex. And so I've had to do quite a few cleanup jobs on cases that involve annuities, because typically I'm able to do some planning and able to address them before we submit an application. But after an application is submitted, it's a bit more difficult. So I think the takeaway with annuities is just know they have to be disclosed. The rules are complicated, and every situation is different to determine what Medicaid is going to do with that. So in addition to what was just mentioned, the purchase of annuity can also be penalized. I've briefly touched on penalties, and I will touch on it more, but this is something that, if it's not done correctly or if it's not remedied correctly, can also mean that someone's eligibility is going to be penalized, which means Medicaid's not going to pay for it. And that person is going to be stuck with figuring out, what do I do? Medicaid's not covering it. How do I resolve this? And the takeaway again is that it's much easier to try and resolve it before your application is submitted than after. So, can't stress enough, if you've got a situation with annuities, it's really best to just have an attorney take a look at it, because every situation is different. So community spouse rules, I see a lot of community spouse cases, and it's important to know the rules and understand that Illinois and the federal government have put in some protections to try and prevent what we call spousal impoverishment. So the community spouse is able to receive a contribution from the nursing home spouse's income. So touched on this, basically, if you don't have $2,739 in income, you can take from your spouse who's in the nursing home to get yourself up to that point. I've also had cases where maybe someone does have $2,739, but they need more. They simply just have too many expenses. Their spouse in the nursing home has plenty of income to give them, but so we actually are typically able to go to court and get an increase in that amount, as long as we can prove exceptional circumstances. So there's situations where this just works wonderfully to give that community spouse some extra breathing room, but we do have to go through the process of going through a hearing, dealing with the Medicaid attorneys to actually get that number up. So community spouse assets. So all assets of the institutionalized spouse and the community spouse are going to count when we're determining someone's eligibility. So I see, many times when I'm in an initial consultation with a client, and there's this kind of perception that, if the community spouse has separately held assets, perhaps they received an inheritance and they just kept it all in their name, that doesn't count. Well, my answer is that it does. It doesn't matter whether it's a joint asset, whether you kept it separately held, that is going to count in determining your spouse's eligibility. So the standard allowance is this number, $109,560. So any non-exempt asset, we just kind of walk through some of the common exempt assets, is considered available to pay for care. A little bit of a typo there, but that's the key number. But the court can allow, if similar to what we can do with the income, the court can allow a greater number than $109,560, as long as you prove circumstances that necessitate you being able to keep more money. So there's certainly an option there. We also have a concept called refusal to support, which is typically best works when I have a community spouse who does have a lot of assets titled in their individual name. And a couple of things have to be done. The spouse has to submit a statement that they are refusing to support. And then the nursing home spouse has to assign his or her right to support from their spouse to the state. So theoretically, even though we can do this and we can allow the spouse who's in the community to keep more assets, we may still be opening them up to a legal action by the state, because the state's going to be given the right to kind of pursue that. Refusal to support is a complicated concept, doesn't make sense in every situation. And so it's something that if someone, if a community spouse certainly thinks they need more than that 109,560, that they should be consulting with an attorney to determine what makes the most sense. So non-allowable transfers are those that are made for less than fair market value. So Medicaid in Illinois has a 5-year look-back period, which means if I submit an application in June of 2021, that Medicaid can look back as to what was done with the applicant and the spouse's assets and income in the 5 years preceding June of 2021. And what they're looking for are transfers. And that's where I or my spouse give away money, property, income, assets, etc., and do not get fair market value in return. And Medicaid's going to be able to presume that I didn't get fair market value in return unless I'm able to show an exception or to demonstrate otherwise. So here are several of the allowable asset transfers. I am not going to go through all of them because I do see we're getting close to 1 o'clock. But I will just note that the typical protections that are available with asset transfers are for blind or disabled children to a community spouse, as long as it's within the community spouse resource limit or as the result of a court order. Transfers to certain trusts that are allowable. And also transfers where if it's determined that, a denial as a result of these transfers would create an undue hardship. So there's options, but I think the takeaway is if you've got a bunch of transfers in that 5-year look back, you need to be very much aware that Medicaid is going to have a presumption on their side, and they're going to be able to impose a penalty unless you overcome that presumption. So during that time, you're not going to be eligible for Medicaid coverage of long-term care costs. And they're going to calculate it based on what is your monthly private pay, and then when and how much did you give away. So if I gave away $10,000 in my 5-year look back and my monthly cost of care is $10,000, I have a 1-month penalty. And that penalty period actually isn't going to start until I'm receiving long-term care and I'm otherwise eligible for Medicaid. So if it's just me, my penalty period is going to start when I'm in a facility and once I'm actually otherwise eligible, which means once I've spent myself down to $2,000. So if you can envision this scenario, I've got this 1-month penalty, I've got $2,000, I'm not going to have a month, I'm not going to have enough to pay for that 1 month. And the nursing home, of course, is going to want to get paid. And so you're certainly going to have some issues there in trying to figure out how's the care going to be covered. But that being said, we certainly are able to kind of try and plan around these things. Facilities that have someone who has a penalty period can apply for a hardship waiver to essentially waive that penalty period. I don't do a whole lot of that because typically that request does go through the facility. So the department does have to notify people of these penalty periods, and they do have to notify of a decision on any hardship waiver. Someone does have the right to appeal a penalty period if they can present credible evidence that they've tried to recover assets, that it was theft, fraud, elder abuse, or other misappropriation. In that case, they're looking for referrals to law enforcement, or if they've just got some other information that shows that that this was not that fair market value was received in return, or this was for some other purpose. So payments to caregivers, on this, I do want to note that Medicaid has another presumption on their side that if a family or a friends or family are providing services, that they're just doing it out of the goodness of their heart. And unless you've established a contract with them before these services are provided, and then provide receipts, logs, or credible documentation, they're going to be able to penalize those transactions. So if people are coming to me and they're saying, I'm providing care for a family member or loved one, we always try to kind of get those contracts in place, because otherwise, if you have to apply for Medicaid, those payments could be a problem. So Medicaid treatment of trusts, I could do probably an entire presentation on third-party trusts and on OBRA payback special needs trusts. I think my big takeaway from this one is I do see people who come to me and they've done your kind of classic revocable trust, known as a living trust, and they think by doing that and putting their assets in it that it doesn't count for Medicaid. That is not the case. The revocable living trust is nothing to protect your assets, your typical one. Irrevocable trusts and some of these third-party, these OBRA trusts, which are typically done when we have people who are under the age of 65. Those transfers to those, the establishment of those are going to give some protection when we talk about Medicaid, but your typical traditional revocable trust is not going to. So I think I'm right. I'm not going to dive too much into these trusts because I know there's questions and we're right at 1 o'clock. So I am going to just take a look through these questions. Okay. So the question was, 109,560 is for a couple. What is the standard asset allowance for a single person? That's $2,000. And 109,000 is when we have a community spouse. So we have a spouse who's at home, and $3,000 is if we've got both spouses in a nursing home.
Melissa, thank you so much. It's Carol Razzle from ElderWorks again. Thank you for an informative and wonderful presentation. I've put contact information in the chat box for everyone. We appreciate everyone coming on today, and thank you very much to Gina Goggio and Senior Helpers for sponsorship. Melissa, we appreciate it. Dutton, Casey, Mesoloras, you're wonderful partners of ours and trusted, and we do thank you very much for all of this very beneficial information. So
yes,
we'll look
thank you.
Yes, we'll look forward to seeing everyone next time. We will be running our second series on interactive town hall meeting with elder law attorneys, and that will be August, September, and October, and you'll be receiving information on that shortly. Thanks again. Have a great day.
Thank you.
Thanks, Melissa.
Bye.